Good evening. This is Salam Immigration. It is 21st of September 2019 today. I'm here to share with you something about the European regulations for free movement. We are facing Brexit nowadays. We don't know whether we will be leaving the EU or EEA on the 31st October, or we may have it extended, or there may be a second referendum, or it may be abandoned at all. It's not clear as yet, but still the European free movement rights would continue for some time. There would be transitional provisions. So far, if there is no deal, then we have a problem. But if there is a deal like whatever we have with Theresa May's draft, there would be transitional provisions till December 2020, and things would still go on almost the same way as they are at the moment, even after Brexit. The UK government, or I would say the UK lawmakers, are minded to somehow protect the interests of the Europeans who are here in the UK already, and also to ensure that the British nationals or the UK nationals who are in the other countries of the European Economic Authorities or EEA, their rights are protected. They are given the same protection that they have at the moment. Like we have millions of UK nationals living in Spain, and we have to protect their interests. So the whatever is the political rhetoric, the idea behind still is to somehow protect their interest by not doing something which offends the other countries of the European Union, so that they do not treat the UK nationals in the other European countries in accordance with the norms of the society. Whatever happens, but at the moment and for some time, the EEA regulations made by the UK government would still continue at least for quite a considerable time, maybe uh, even beyond 2020, when there would be some litigation going on. It will be still on the basis of these regulations, which may find their way, or they would be a part of some other document, like the exit documents would still, I would say, continue for quite some time to be based on the EEA regulations. And these EEA regulations have stemmed from the Citizens Directive of the European Union 2004. We call this as a directive for free movement of people within the European Economic Authority. Like if someone from France wants to come to the UK, he can sit on a bus and come to the UK without any visa, without any permission. All he needs to do is to show his passport or identity card that he is a French national, and therefore he is allowed to come and start living in the UK. For the first 90 days, there is no problem, even if they don't do anything. But after 90 days, they have to somehow be economically active, or otherwise they should exercise treaty rights. Exercising treaty rights can be in a different way also. The normal way is to come here and start working, and when you work, you are economically active. You are considered as exercising treaty rights. Sometimes someone comes here as a student. A European comes to the UK for maybe better education. He would also be exercising treaty rights while he is in education, provided he has his private medical insurance. Since he would not be having any salary from where national insurance is deducted and which goes for the NHS or for the medical insurance, as we may consider NHS. So that's why they need a private medical insurance. Another way of exercising treaty rights would be if someone comes here and says, I'm self sufficient, I've got enough resources, I've got enough savings, so I don't need to work. So, if that is the case, then they will have to demonstrate that they have those means, and they will also have to have a private medical insurance. So, the European Union nationals from the EEA countries can come here together with their families, and in case their family members are not European uh, nationals, they are not EEA nationals, even then they have rights. Free movement means that if an EEA national wants to move within the EEA countries, he will not be able to move freely if he cannot take his family members with him. If he cannot live with them, or if they cannot live with him in the country where he moves, then this is not free movement. That this hinders the free movement. So the rights of the non-EEA family members are also protected. After 90 days, the European Union national, EEA national, has to make an application or to somehow become automatically entitled to be here by exercising treaty rights. And if he continues to exercise treaty rights for 5 years, continuous block of 5 years, he would be entitled automatically to a permanent residence. Now we have, because of Brexit, a different regime also going side by side, which is settled status and non-settled status. The UK government has introduced these schemes as part of the Brexit or as part of the exit from the EEA document, so that it is not dependent upon the continuity of UK being a part of the EEA, so that these documents, these settled and non-settled status documents, would be UK documents independent of the EEA regulations and would continue even if we are not part of the EEA. So these are called, I would say, Brexit documents. So if someone would now apply for permanent residence or would now apply for a 5 years residence card, uh, would have the same rights as if he applies for a non-settled status or settled status. But the good thing or the difference I would say practically is that the applications under the settled and non-settled status are being decided faster and more liberally, and the government is trying to encourage people to get their papers sorted out rather than get the permanent residence or the 5 years residence card and then again apply for something else when we are out of the European Union or out of the EEA, because then there will have to be some document which is not from the EEA regulations, which will be scrapped or which will find their way somehow into the UK legislation. What they have offered is, apart from this online facility, what they are doing is that they have even introduced an app on your mobile. You can download that app and make an application by just filling in very, very fast on that app, and they will, by way of emails, grant you the status or ask you for more information or refuse you. So this is a very fast and very modern way of approaching this, because they think if there are millions of applications pouring in a short while before uh, Brexit or shortly before Brexit or immediately after Brexit, then there will be a big problem for the government in handling those applications. So it is advisable now, rather than making applications for a 5 years residence card or residence certificate, you may apply for the non-settled or the settled status. Now coming to the rights of the non-EEA family members, this is an area of discord. There's a lot of litigation and a lot of issues that have risen out of the interpretation of the various provisions of the directive and of the regulations uh, relating to such family members. We have two types of family members. One is called family member and one is called extended family member. A person's spouse, husband or wife, and children under 21 are family members. Similarly, a parent who is dependent on them is also a family member. All others are extended family members if they are related in some way, like brothers and sisters, siblings, aunts, uncles, cousins, nephews, nieces. They can be extended family members. Now, allowing unlimited family members to, or unlimited extended family members to come and live in the UK or live in the other parts of the EEA if they are coming from, say, UK or other countries would be somewhat too much. So they have restricted it to only those extended family members who are dependent upon the EEA national. So that means while they are overseas in their own non-EEA country, they are dependent upon the European national here, and when they are invited and they join him here, they are still dependent. They continue to be dependent. Alternatively, they can be a member of the household of the European national. Like if an EA national has himself been living in some other country and within his household, in his house, some extended family member has been living as part of that household, even if they are not dependent, even if there is no exchange of money or money transfers, they can still come and be accepted as extended family members and issue the relevant documents if they come to the UK and again become a member of the household of the European national. That is, they start living in the same house as the EEA national is living, or a house which is owned and occupied or maintained by the EEA national. So this is an area which requires uh, evidence and proper handling because the Home Office has been a bit tough in such cases. Even there was an issue with the right of appeal for such persons when the extended family members were refused. Previously, they were having a right of appeal, but later on there was a decision by the upper tribunal saying that the regulations do not provide or do not appear to provide the right of appeal to such extended family members. But the matter was then resolved by the Court of Appeal when they decided that no, clearly there is a right of appeal for such extended family members. But unfortunately, in the meantime, when the government or Home Office, whosoever you say, is impacting the changes in the regulations. So they brought a change in the regulations that extended family members would not have a right of appeal. So it was then expressly provided. But because of the Court of Appeal decision, then the government decided that after that we should not uh, challenge any right of appeal. So anyone who now makes an appeal to the first year tribunal against a decision to refuse an EEA nationals, extended family members, they can challenge that decision in the first year tribunal. Now, dependence is something which is quite vague, but the Home Office have issued a guidance for extended family members in which they have somewhat tried to make it simpler to understand or make it clearer what they would accept as dependence. So they say that half if half of the living expenses of the non-EEA national are met by the EEA national who is sponsoring them, then that would count as dependence. If it is not more, if it is not that important, if it is not even 50% of the living expenses that the EEA national is contributing, then we can't say that the non-EEA national is dependent on the EEA national. So dependence cannot be for a very small amount or for only a small aspect of the life of someone. It should be something major, something very important. So half of the living expenses is something important. If someone cannot bear their living expenses or half of the living expenses, then it is considered a real dependence. Among the extended family members is also unmarried partners. In the West, we have unmarried partner as an accepted form of relationship which has to be respected. So that's why the durable relationship concept has been introduced in the regulations and also the directive, that if someone qualifies as a durable partner, the durable partner is not very well, say, explained or not even defined. So if someone qualifies to be a durable partner, then they should also be allowed to live with the EEA national so that he can exercise his rights of free movement. Now, with the durable partners, we would not say that someone is a durable partner if he has lived with the other partner for a number of years, like we have in the immigration rules for uh, non-EEA persons, in which the criterion under the immigration rules is that the uh, unmarried partner has to have cohabitation for at least 2 years before being accepted as a partner. This is not so under the European regulations or the EU regulations, where someone can be a durable partner for uh, someone even if he has or she has lived with the other one for less than 2 years. It can be 1 year, it can be 6 months. Like in some cases, the relationship can be demonstrated as very strong, even if it is, say, 1 year. In some cases, if there is a child involved, if they have a child together, then it is quite a strong ground that the partnership is a durable partnership if they are living together for a shorter time. There are a number of topics which can be discussed and which are of interest, but because of this being a basic video, so I would not dwell in too much detail. Some important things I would like to say for summarizing the whole thing is: number one, that these cards or certificates or settled or non-settled status, these are not mandatory. Someone who qualifies, he simply has acquired the right. He may not have any card, he may not have any certificate, but if he meets the requirements, then he is lawfully here. It is not like the normal regulations, the immigration rules, where unless you are granted leave to remain, you don't have a leave to remain. Here, these are automatic rights. These are required automatically. Like if someone is here in the UK unlawfully and suddenly he marries an EEA national who is exercising TT rights, he immediately becomes legal here and he has the right to work without any further documents. He can start working maybe as a self-employed person. If he wants to go for a job, they may ask him something. They can't say, okay, it is automatic, but how do we know? So they may ask for documents. So that's why they are advised that they should still get a document to assist them, that they can go for jobs and acquire all other services. So permanent residence is acquired in 5 years' time. If someone is here for 5 years as an EA national exercising treaty rights, he gets permanent residence or a settled status, and in another 1 year he gets nationality. Similar is the case of his family members. The family members do not have to work or do anything like exercising treaty rights. They are just attached to the EEA national. If the EEA national gets permanent residence and they also have lived with the EEA nationals for 5 years, or they have lived in the UK in accordance with the regulations, they also get permanent residence. There is some protection for partners where the marriage breaks down before 5 years. So there's a concept of retained rights of residence. If the marriage has broken down not before 3 years, then they can retain the rights of residence and spend the balance 2 years or whatever is left out of the 5 years and work or say do actions as if they were a European national to complete the 5 years. There is generally a right of appeal in all European cases decisions. It's not like the other immigration rules. Deportation is an area which is dealt with differently in the European regulations. It's not that someone who has been sentenced for 12 months or more would face automatic deportation, like what is the case with the uh, other non-EEA persons who are not family members of EEA nationals. Here, the idea is or the concept is that if someone is to be excluded or if someone has to be expelled, then it has to be seen that they genuinely and presently present a threat to the fundamentals of the society. Only then they can be uh, removed from the country on that basis or deported. Deportation law is also uh, entwined with the regulations, so they can also be subject to the deportation procedure, but the criteria would be different. So if someone has not acquired permanent residence, the lower threshold applies. They can be expelled on the basis of public policy or public security or public health. If someone has acquired permanent residence, then there have to be serious reasons, and if someone has lived here for 10 years, then the reasons should be imperative, very strong. So it is a higher threshold as compared to the non-European immigration